Good evening, friends. I welcome you to this webinar series. Friends, you are aware, Chamber is regularly doing these webinars on different topics. This time, Direct Tax Committee thought that they should also organize on the topical subject of prosecution, compounding, and charge of abatement against professionals under the Income Tax Act. To speak on that, we have a young and dynamic advocate, Aditya Ajgaonkar, become from NM College, LLB from Mumbai University, and did LLB General in Cardiff University, UK, with an emphasis on constitutionalism and economic offences. He appears in variety of matters before the Bombay High Court, Income Tax Appellate Tribunal, Bombay City Civil and Session Court, at various magistrate courts. With this, I present before you Mr. Aditya Ajgaonkar, and I am sure that you will have a very educative evening this today. Before I request Aditya to speak, I will request Mr. our Direct Tax Committee Chairman, Mr. Ashok Mehta, to offer a memento as mark of our love and remembrance.
Good evening. Hi, the Aditya here. Today is an interesting day. I've been asked by the committee here to help inform professionals on prosecution. Now, a lot of us over a lot of years have been very complacent regarding the fact that, honestly, when additions are made under the Income Tax Act, we just fight out the penalty, and prosecutions, if at all, were very rarely lodged in the past. Well, times seem to be changing. I have been seeing that the trend is that prosecutions are being lodged extremely aggressively, and I think the trend is going to go up. It's going to go up on an upswing. And as tax professionals, as people who are responsible towards our clients, people who are responsible towards what our clients do, as far as the Income Tax Act is concerned, it is up to us to make sure they do not fall within the four corners of offences as brought out by the Income Tax Act, which would subject them to prosecution. Especially because a lot of us have clients, a lot of us have people relying on us who have very limited taxation knowledge. They depend upon us for everything. And it is my belief that this being just the tip of the iceberg, our Chamber of Tax Consultants, along with all the associated people with it, shall lead the way ahead to make sure that this floodgate of litigation that is opening up in the form of prosecution and various sorts of actions to be taken against the public at large can be contained, not as far as the offences themselves are concerned, but to make sure that we do not help our clients fall foul of those sections. With that, I start the seminar. Slide is on.
सिस्टम में से चल रहा है नहीं ये हम लोग को दिखाएंगे सिर्फ वन में किस
नहीं can we see I'm sorry for the technical difficulty. Looks like well, we'll get started on the presentation. My name is Advocate Aditya Ajgaonkar, as I've already been introduced. We are dealing with Chapter 12 of the Income Tax Act, which refers to prosecution and there are various offences as contemplated, various sections that are involved. Section 275A, 275B, all the way to 280D, as enumerated on the screens before you. The main basis for stringent prosecution that was brought out against assessees was brought out by the Vanchu committee report. Now, what they have said rings true today. I think it rings true with the current. It runs true with the current disposition. They said the provisions for imposition of penalty failed to instill adequate fear into the minds of tax evaders. Prospect of landing in jail, on the other hand, is a far more dreaded consequence. To operate in terrorism upon the erring taxpayers, besides, a conviction in a court of law is attended with several legal and social disqualifications as well. In order, therefore, to make enforcement of tax laws really effective, we consider it necessary for the department to evolve a vigorous prosecution policy and to pursue it unsparingly. I would emphasize on vigorous prosecution policy and unsparingly. It would be a sign of things to come.
Sorry. I just want to play this show first.
What is it all right?
Yeah, because I'm not getting your PPT.
PPT is not coming.
Yeah, this pause actually.
Now?
Just check it.
Yeah.
Change not showing screen. I'm so sorry for the technical difficulties. Okay.
I should pause my person. Yeah.
Yes.
Yeah, fine.
Sorry, I think we've got video again. So as I was saying, the Vanchu committee report is currently there on your screen. So, of course, prosecution has been lodged because penalty provisions have been considered inadequate. Penalty apparently does not contain enough stigma in the society to instill fear in the hands of the taxpayer anymore. So, vigorous prosecution policy has to be initiated, and it should be pursued unsparingly. The government today is, of course, trying to make true on this and making sure that tax collection is at an all-time high and errant players pay for their misdeeds. Before we get into anything else, Chapter 12 per se has enumerated a large list of prosecution of offences. We will be dealing only with a selective few. We will not be dealing with all the provisions. My effort through this presentation, through this slideshow is, and my brief is, to show how we can get out of prosecution proceedings. So we will be dealing majorly with compounding, we will be dealing majorly with discharge, quashing, and we will be dealing with revision powers of the High Court, and as far as mens rea is concerned. So there it is the CRPC is applicable in the case of income tax proceedings in prosecution as per section 280D, which says application of Code of Criminal Procedure 1973 to proceedings before a special court. Now, all the offences that are brought out under the Income Tax Act are triable by either special court or judicial magistrate first class, depending upon how the matter is, when they're designated as a special court. So, in all these proceedings which are there before the said special court, they will be the rigors of Criminal Procedure Code will apply to them. This is a marked departure from the saying that the Income Tax Act is a code by itself and the normal procedural codes as well as the normal rule of evidence do not apply to it. As per Chapter 12, all the offences that are made out will be subject to CRPC. Now, when we receive a notice as far as prosecution is concerned, usually the first step is to reply to the said notice. This notice can be replied by either through an authorized representative or by the person himself. Usually in this notice, we bring out a prima facie case of why prosecution should not be lodged against us. We shall be touching upon whether this notice or an opportunity to be heard before giving sanction for prosecution is required or not later. But let us come, there is an inescapable conclusion that you have to bring out a prima facie case of why prosecution should not be lodged against you. Let us for a moment assume right now that despite your reply, prosecution has been lodged against you and you wish to quash it. Then what are the remedies available to you? Usually the first step to go on is the High Court for everyone. People rush to the High Court simply because it seems to them that that is going to be the place that will give them relief. Now, Section 482 of CRPC provides for saving of inherent powers of the High Court to make sure that whatever, to make such orders as may be necessary to give effect to any order under this code. By this code, they mean CRPC, or to prevent abuse of the process of any court or otherwise to secure the ends of justice. This is extremely important because when we reply to the notice and assuming that the prosecution has been lodged against you, if you wish to make sure that you do not stand trial, you can apply under section 482 of the CRPC, which invokes up the writ jurisdiction along with the saving of the High Court's inherent powers. But in order to get relief under this section, you have to show that the said petition is necessary to give effect to any order under CRPC or to prevent abuse of the process of any court. So we have to show under the section 482 that if the said prosecution is not quashed, it will tantamount to the abuse of judicial process, a waste of judicial energy, and that there is no case against the person. Usually section 482 cannot be invoked when there is another remedy available. Inherent jurisdiction under this section has to be exercised sparingly, carefully, with caution, and only when such exercise is justified by the tests laid down in the section itself. We have tried as far as possible to make sure that we rely on Supreme Court judgments so that they are applicable on a pan-India basis. But without any doubt, Section 482, though it is often used by people as a first resort, actually is to be used only in rare cases. Inherent powers of the High Court are extremely wide. They are allowed to make, they have the inherent jurisdiction to make any orders to meet the end of justice. So, if you manage to prove that the prosecution would tantamount to an abuse of judicial process of any court, Section 482 allows the High Court, by utilizing its inherent powers, to quash the said proceedings. This cannot be invoked when there is another remedy available, just like writ petitions do not lie in normal tax matters when there are appellate proceedings available. This is because when there is a clear-cut remedy available, the legislature as well as the courts try to discourage people from rushing directly to the High Court in using inherent powers. This is a clear reason. The clear reason for why this is made possible, why they say that this cannot be invoked when there is another remedy available, because this increases the docket of the High Courts. This adds a lot of this adds a lot of pressure on the High Courts. A lot of petitions would lie directly to the High Court if this was not used sparingly. Quashing of charge is an exception and not the rule, as laid down by Supreme Court. Quashing of charge, there is no presumption that if you go to the High Court, the charge shall be quashed. That is because a lot of issues, as we can bring out, are subject matter of evidence. So Supreme Court says that quashing of a charge is an exception and not the rule. The Criminal Procedure Code by itself does not specifically give any power to the court to quash proceedings. As strictly construed in legal parlance, this power is derived from the inherent powers contemplated under Section 482 of the Code. Hence, as this, to enumerate what we have just said, the power is an inherent power that is vested statutorily in the High Court through the Constitution of India and CRPC. The powers would usually be exercised in the writ jurisdiction when we try for quashing. They should not ordinarily be used when there is another remedy available. Inherent jurisdiction has to be exercised sparingly, carefully, and with caution, and only when such exercise is justified by the test specially laid down by the section itself. And the tests are exhaustive. The tests are to prevent abuse of process of court, to give effect to any order under this code, or otherwise to secure the ends of justice. The other alternative that is there before the assessees who have been made accused in criminal prosecutions are to apply for discharge. Now, discharge applications can be filed before the trial court, before the charges are framed, though the name discharge would suggest otherwise. The stage of discharge is before charges are actually framed. Section 277 of CRPC deals with discharge. It says, if upon consideration of the record of the case and documents submitted therewith, and after hearing submissions of the accused and prosecution in this behalf, the judge considers that there is not sufficient ground for proceeding against the accused, he shall discharge the accused and record his reasons for doing so. Hence, Section 277 is very clear. It gives the accused an opportunity of being heard as well as the prosecution. The judge should necessarily be satisfied that there is not sufficient ground for proceeding against the accused. This will be a prima facie observation, simply because this is before framing of charge. Evidence has not really been gone into, and only if he is satisfied that there is not sufficient ground for proceeding against the accused, he shall discharge the accused and record his reasons for doing so. Only prima facie cases to be seen. Whether the case is beyond reasonable doubt is not to be seen at this stage. Now, we are aware that the burden of proof in criminal prosecution upon the state is very heavy. The burden of proof, very specifically, we might have heard in a lot of movies, a lot of programs, is beyond reasonable doubt. Beyond reasonable doubt refers to a doubt which would possibly resonate with a reasonable person. The doubt does not need to be absolute, just reasonable. The sufficient ground referred to in section 277 refers to ground for putting the accused on trial and not ground for conviction. Therefore, the sufficient ground which is referred to under section 277, at this stage, the court shall not go into the merits of the case. The court shall only prima facie see whether there is sufficient ground for putting the accused on trial, and not whether the final outcome of the case would be in the favor of the accused or not. This would usually refer to the various materials that are put forth before the court, before framing the charge, in order to show that there is some prima facie case made out against the accused. If there is no prima facie case made out against the accused, if there is no material on record that is brought, sometimes there may be procedural lapses, then the accused can apply for discharge. However, assuming we have moved on beyond the discharge process and we have moved on to a place where charges have been framed against the accused, in this case, though the inherent powers can be used by the High Court, what is usually lies is a revision. Revision enables a High Court or any sessions court under section 397 of CRPC to call for and examine the record of any proceeding before any inferior criminal court situated within its or its local jurisdiction for the purpose of satisfying itself or himself as to the correctness, legality, or propriety of any finding, sentence, or order recorded or passed, and as to the regularity of any proceedings of any such inferior court, and may, when calling for such record, direct that the execution of any sentence or order may be suspended, and if the accused is in confinement, that he may be released on a bail or on his own bond pending the examination of record. Thus, we can see that if any order is passed by a trial court which is not appealable, a revision lies. The normal course of going about revision is that we do not directly apply for revision directly to the High Court. The sessions jurisdiction is usually invoked because the special court is a joint magistrate, chief metropolitan magistrate first class. Hence, this hence the revision from a special court under the Income Tax Act will lie either with the High Court or a session judge. The powers of revision are combined and enumerated between section 397 to 405 in CRPC. All magistrates, whether executive or judicial, and whether exercising original or appellate jurisdiction, shall be deemed to be inferior to the sessions judge for the purpose of this subsection and of section 398. If an application under this section has been made by any person either to a High Court or to the sessions judge, no further application by the same person shall be entertained by the other of them. Section 397 and 398 of CRPC. These are extremely important because these clearly show that all magistrates, whether executive or judicial, shall be deemed to be inferior to the sessions judge, and hence that is the sole reason why a session judge can exercise the revisionary jurisdiction upon the proceedings. It also shows that the powers of High Court or sessions judges to entertain such revision are coterminous. You can either choose the forum of either going to the High Court or the sessions judge. There is no express bar from selecting which one. It could be as per convenience, as per cost, and any other factors. Section 397 of CRPC gives complete discretion to the accused to decide whether the revision needs to be filed in the sessions court or the High Court. Powers of revision are, as said, usually exercised in cases of orders against which no appeal lie. Revisional jurisdiction of the High Court can be moved directly. There is a direct pronouncement of this by our Honorable Supreme Court. Usually, as said, propriety demands that the party should first approach the Court of Sessions. This is an underlying theme in all the remedies that are there before CRPC. Unless there is exclusive jurisdiction of the High Court in any matter, if there is any other recourse in law that is available to any assessee or accused, as we can see even in the Income Tax Act, it is always preferred that the inferior court or the court that any other court except the High Court first approaches the court, is first approached. There are multiple advantages to this. A, because Court of Sessions is an inferior court to the High Court itself, you would get two opportunities for revision instead of just one. It is quite another fact that if you directly approach the High Court and the High Court makes any observation or passes an adverse order in the revisional jurisdiction, then the relief would lie only with the Supreme Court. On the other hand, if the Court of Sessions is approached first, then we get two more opportunities for revision. A, the High Court, and B, the Supreme Court. It is also extremely important to appreciate that the High Court and Sessions Court jurisdiction, which is being right now, which is being exercised for revision, is mutually exclusive. If you choose one forum, you cannot go to the other. However, once a session court has already exercised its jurisdiction and passed an order, then the High Court can always be moved in order to get relief under this section. This revision is not the revisional jurisdiction of the High Court is not restricted only for discharge, or not only not discharge, is not to be exercised only after charges are framed wrongly. They can be used for stay, they can be used for any application from which appeals do not lie to a higher court. Well, we've prematurely reached bail. Bail is a rather hot topic because, of course, everyone is interested on how they can get out of jail. Let us, for the sake of enumerating, go through the bullet points. Bails fall under two categories: bailable and non-bailable. Often laymen think that a non-bailable offense means that bail is not possible to be, that you cannot receive bail in it. In a bailable case, a grant of bail is a matter of course. In a bailable case, you are arrested, bail is given to you upfront to make sure that you are present in court, but you get it as a matter of course. It can be said that it is a right of a sort. But in a non-bailable case, this is subject to the judicial discretion of the court. The bail refers to a process of procuring the release of an accused by ensuring his attendance. Bail is the rule, jail is an exception. Has been read by right of liberty in the Supreme Court. They've said that bail is the rule, jail is the exception, because if jail is used, if it is assumed that jail is the rule and bail is the exception, then your right to liberty gets highly infringed. It is also said, it is also interesting to note that the court can refuse bail even if offence is bailable if conditions imposed while granting bail are violated. Let's enumerate. There are two kinds of offences, bailable, non-bailable. The Income Tax Act, of course, has both sort of offences, bailable as non-bailable. In case you're accused of a bailable offences, bail will be given to you a matter of course. Upon arrest, you will be released on a bail bond, usually immediately. You will not be taken into custody. A bond will be taken subject to the conditions of the bond. You will have to be present in the court on each date that it is that is called out. The bail bond is usually tendered to make sure that you appear in court. In a non-bailable offence, you will be arrested forthwith. Bail is not a matter of course or a matter of right. You will have to move the trial court to ask for bail in the case of a non-bailable, in case your offence falls under the non-bailable category. What is important is that it does not make a difference whether bail is bailable, whether your offence is bailable or non-bailable. In case you violate any conditions of bail, the court has the right to refuse further bail or to take you into custody. The main purpose of furnishing bail is to make sure that you do not abscond or you do not miss the trial or prolong the trial, and therefore it is of essence that you make sure you adhere to the terms of the bail. In the case you do not adhere to the terms of the bail, there is a high chance that your bail may be cancelled and a warrant may be issued against you. An interesting field of litigation that has come up is anticipatory bail. Anticipatory bails are are very subjective. Anticipatory bails are not as easily got as bail. First and foremost, what is extremely important to understand is anticipatory bail is not required in a bailable offence, because bail is given to you in a bailable offence as a matter of course. There is no requirement of going to get an anticipatory bail because bail will anyways be given to you. So section 438 of CRPC says where any person has any reason to believe that he may be arrested on accusation of having committed a non-bailable offence, he may apply to the High Court or the Court of Session for a direction under this section that in case of the event of such arrest, he shall be released on bail. When they say apply to the High Court or to the Court of Session, it is again, you always have to choose one forum, just in the case of revision. Usually the right way is to approach the Court of Session. If you go directly to the High Court, there is a chance that the High Court may say, please exercise your remedy in the Court of Session first. So the right way to go about for anticipatory bail is to file an anticipatory bail application in the Court of Session. The court has very wide discretion into giving bail. As wide as discretion of giving normal bail is, anticipatory bail discretion is even larger. You have to fall strictly within the four corners of the statute. The court may, after taking into consideration the following factors, namely A, the nature and gravity of the accusation, the antecedents of the applicant, the possibility of the applicant to flee from justice, where the accusation has been made with the object of injuring or humiliating the applicant by having him so arrested, either reject application forthwith or issue an interim order for grant of anticipatory bail. It is to be noticed that a lot of states have made various statewide amendments in CRPC to change certain parts of anticipatory bail. There are different amendments in Maharashtra, there are amendments in Orissa, etc., that will change the statute slightly. So let us go into the ingredients which need to be satisfied as far as anticipatory bail is concerned. A, the court will necessarily go into the nature and gravity of the accusation, how big the accusation is, what sort of offense is contemplated. Prima facie, it will depend upon what chances there are of the accused being actually guilty or not. They will also go into the antecedents of the applicant, whether the applicant is a habitual offender or not, whether this sort of behavior is normal, what are the surrounding circumstances in the past history of the applicant, whether he has been convicted or under trial for other matters before. The possibility of the applicant to free from justice. This is usually the strongest point anyone has for refusing anticipatory bail, because there is always a high chance that an applicant may get anticipatory bail and then flee justice before any warrant is issued, before any proceedings are actually initiated before him. It is usually, therefore, very important to show that you will cooperate with the investigation, you will not flee from justice, and there are certain other conditions that may also be imposed. Another consideration that is always has to weigh on the court's mind while giving anticipatory bail is whether the accusation has been made the object of injuring or humiliating the applicant by having him so arrested. This is a highly subjective factor. It is extremely important that your averments regarding the satisfaction of these considerations need to be positive, and you have to fall within the four corners of these to get anticipatory bail. It is all the flip side to anticipatory bail is if interim protection is not granted, the concerned officer may arrest the applicant on basis of the accusation in such application, apprehended in such application. There are cases where anticipatory bail is denied and the applicant is arrested forthwith. Only, as I mentioned before, only in exceptional cases shall an anticipatory bail application, we refer to it as an ABA application, be moved directly before the High Court before first approaching the Court of Session. Rejection of an anticipatory bail by Court of Session does not disentitle the High Court from entertaining it under its original jurisdiction. When an ABA is rejected by Sessions Court, fresh application on the same ground cannot be made before the High Court, and a revision is maintainable from the order granting refusing ABA in High Court. Now, anticipatory bail is of course not restricted only to income tax, but we shall realize that there are various judgments of various High Courts that peacefully coexist or sometimes are at a variance with each other when it comes to provision of the CRPC, it being a central act with a lot of state-wise amendments. So the Gujarat High Court says that an ABA application shall be moved directly before the High Court only in exceptional circumstances. This seems to be a rather popular view. The rejection of anticipatory bail by Court of Session does not disentitle the High Court from entertaining it. This per se has to be harmoniously read. This is what the Kerala High Court said. But then there are also judgments of the Calcutta Division Bench that says that when an ABA is rejected by Sessions Court, fresh application on the same ground cannot be made before the High Court. Therefore, if the Sessions Court refuses rejects your ABA, then you cannot make a fresh application on the same ground. So what happens if your ABA is rejected by the Sessions Court and you cannot make a fresh application on the same ground? Then you can use the revisional jurisdiction that has been mentioned beforehand, because the Sessions Court is an inferior court as opposed to the High Court, as contemplated by the revisional jurisdiction discussed earlier. Hence, a revision is maintainable from an order granting or refusing ABA in the High Court. They're very important, as it might not have been clear enough, but if an order is granted for ABA, even that a revision can be preferred against that by the state against the ABA granted to you. The question now, the next question that comes up is usually what to do, anticipatory bail or bail. This question may come to a lot of people that are actually contemplating getting out of jail. So the question, the first thing to remember is an anticipatory bail application can be moved before a Court of Sessions or High Court only when a person anticipates being arrested. This is extremely important because when you move an anticipatory bail application before a Court of Sessions or High Court, you have to show that you actually apprehend getting arrested. If you do not anticipate that you will be getting arrested, if it is just summarizes or conjunctures, anticipatory bail application, anticipatory bail will not be granted to you. You have to actually show that there is a high chance that you may be arrested. Bail also will be referred to us right now by regular bail is a matter of course in bailable case and a matter of judicial discretion in non-bailable case. Of course, all of anticipatory bail applications being only for non-bailable cases shall fall within the ambit of judicial discretion. Supreme Court has laid down an important ratio which can be of help. The distinction between an ordinary order of bail and an order of anticipatory bail is that whereas the former is granted after arrest and therefore means release from the custody of the police, the latter is granted in anticipation of arrest and is therefore effective at the very moment of arrest. Therefore, in an ABA, an applicant must make out a prima facie case that he has apprehension that may be arrested. An anticipatory bail does not mean that the accused cannot be arrested at all. It simply means that in the event of an arrest, the accused shall be released on bail as per the conditions of anticipatory bail. So reading, to recapitulate what the Supreme Court says is that, of course, anticipatory bail and ordinary bail are very different. Just like we have a revision application after charges are framed and discharge before charges are framed, anticipatory bail as a necessity is always preferred before arrest. Once you're arrested, you cannot apply for anticipatory bail simply because you're already arrested and there is no anticipation of being arrested. Regular bail application can be moved only after you're arrested. Usually, once you are committed to the court, when you're produced in front of a magistrate, on the first hearing, you may apply for regular bail, and if you fulfill the conditions of bail, bail will be granted to you. Anticipatory bail does not mean that an accused cannot be arrested at all. It simply means that in the event of arrest, the accused shall be released on bail as per conditions of the anticipatory bail. To simplify this, if you have anticipatory bail, then just like a bailable offense, where upon arrest you will be released on bail as per terms of the bail bond, in case you have an anticipatory bail in your favor, upon arrest you will immediately be released as per the conditions of the anticipatory bail. That does not mean you cannot be arrested at all. You will be arrested and then released on bail immediately. In case your anticipatory bail is only till the arrest, then once you're arrested, at the next occasion you may have to apply for regular bail. Excuse me. Thank you. Because bail is such a hot topic, we shall go further into it. So, what are the considerations for the grant of bail? At the time of granting bail, the court shall only look at prima facie material and shall not go into the merits of case by appreciating evidence. In granting or not granting of bail in a non-bailable offense, the primary consideration is the nature and the gravity of the offense. This stands to reason it would be a lot more difficult to get bail if you have murdered someone as opposed to if you've stolen from someone. In the same case, if it is a simpliciter case in the Income Tax Act where the offense is very small, where you are a first-time offender, getting bail would be a lot easier than if you are a habitual offender. At the time of granting bail in cases involving non-bailable offenses, particularly when the trial has not yet commenced, the court should take into consideration various matters such as the nature and seriousness of the offense, the character of evidence, circumstances which are peculiar to the accused, a reasonable possibility of the presence of accused not being secured at trial, reasonable apprehension of witnesses being tampered with, the larger interest of public or the state, and similar other considerations. This has been laid down by the Supreme Court. A lot of these are also coterminous with what weighs on a court's mind, practically speaking, while granting anticipatory bail. The entire conundrum about letting out an accused on bail is usually made worse simply because a lot of offenses are often committed by people who are in a position to tamper with the evidence, who are in the position of absconding, especially in cases of economic offenses. Certain examples come to mind that have made the news very recently. But what also is gone into is how serious the offense is. What is the character of evidence that has been prima facie put forward? This doesn't mean that the court goes into the evidence by appreciating it, but just by taking a prima facie view of whether there's a lot of evidence against the accused, what is the quality of the evidence, whether there are any circumstances that are peculiar to the accused. If the accused is not a flight risk, if the accused is a senior citizen, say 85 or 90 years old, there's a good chance that these are circumstances that are peculiar to the accused, and it will also look at the larger interests of the public or the state and similar other considerations. Just to be noted that these same circumstances also would be considered while the grant of anticipatory bail is being given. Usually while arguing out bail applications, the advocates usually try to make out a prima facie case showing that there is a good chance of the accused being acquitted or that the case against him is extremely weak. If the bail of if your bail is rejected for whatever reason, again it is possible to go into the revision jurisdiction to the High Court. If that is again refused, it is extremely important to note that every time a fresh application for bail is made before the court, if bail is not granted to you the first time around, on the subsequent event, you will have to show that there are some changes in circumstances. You cannot substantially re-argue the same bail application again. We are all struck back by how the current government is being extremely forward-looking by putting economic offenses on a different yardstick, by saying that we will not tolerate people taking the country for a ride. But as we've seen with the Vanshu Committee report, and if we've seen by the Supreme Court judgment that date back to 1987, economic offenses are taken very seriously. As the Supreme Court said, and this may surprise some, the entire community is aggrieved if the economic offenders who ruin the economy of the state are not brought to books. A murder may be committed in the heat of a moment upon passions being aroused. An economic offense is committed with cool calculation and the deliberate design with an eye on personal profit, regardless of the consequence to the community. A disregard for the interests of the community can be manifested only at the cost of forfeiting the trust and the faith of the community in the system to administer justice in an even-handed manner without the fear of criticism for quarters in which view white-collar crimes with a permissive eye, unmindful of the damage done to the national economy and the national interest. This is what the Supreme Court laid down in 1987. There are various judgments of the Supreme Court reiterating this. 2003, the Supreme Court says the entire community is aggrieved if economic offenders who ruin the economy of the state are not brought to book. These are, of course, not ratios per se of the Supreme Court, but they do show, these have been quoted again and again to show how seriously economic offenses are given. As we can see in 1987, Supreme Court has directly compared economic offense with a murder and placed it on a higher pedestal, saying that a murder may be committed in the heat of moment upon passions being aroused, but an economic offense is committed with cool calculation. And very honestly, most of us know that it is very difficult to argue with this. An economic offense in today's world are usually committed because people think that they can get away with it. The factors that, of course, weigh heavily on a court mind is whether an economic offender should be judged on a different yardstick. The answer is overwhelmingly yes. The courts are time and again judging that economic offenses are to be judged on a different yardstick as compared to a normal offense. And well, let's see what the challenges for bails of economic offenses are. The Supreme Court, again, in 2013, very recently says the economic offenses constitute a class apart and need to be visited with a different approach in the matter of bail. The economic offence having deep-rooted conspiracies and involving a huge loss of public funds need to be viewed seriously and considered as grave offences affecting the economy of a country as a whole, and thereby posing a serious threat to the financial health of the country. The Rajasthan High Court in the case of ITO versus Gopal Dhamani in 172 ITR 462 laid down the proposition that jail and not bail is in serious economic antisocial white collar crimes. Rajasthan High Court has appreciated certain judgments of the Supreme Court, and well, it has turned around the old proposition of bail and not jail as laid down by the Supreme Court earlier to say that in serious economic antisocial and white collar crimes, jail and not bail shall be the rule. However, as a relief, subsequently the Rajasthan High Court has also held that there is no force in the contention of the Council for Department that anticipatory bail cannot be granted in cases involving economic offences. Hence, jail and not bail is not an absolute rule. It is an obiter dicta, and of course, whether bail can be granted or not will depend on circumstances of the case. Further, again, the Rajasthan High Court has also held a general principle. This is being laid down, especially considering the case of Gopal Dhamani in 172 ITR 462, where the High Court of Rajasthan holds that a general principle cannot be laid down that in all cases involving commission of economic offences, anticipatory bail is to be refused. What is to be seen is whether in the facts and circumstances of the case, anticipatory bail should be granted or not. So, to recapitulate economic offences, we can see that they're being taken quite seriously by the courts, and not just recently. We're talking even about the 1980s and the 1990s. With the increase in prosecution, we can assume that, and the increase in the media coverage for such crimes, we can always assume that the yardsticks and the directions that are laid down by various High Court and Supreme Court will solidify even further, and that it would not be that easy to justify an economic offense. Usually we tend to get away with economic offenses saying that they have not really harmed anyone, but the Supreme Court has taken a view that in fact economic offenses harm the entire nation, and therefore they should be treated on a very strong footing. It is also to be remembered that economic offenses would not only be curtailed to tax evasion. It could involve FERA, FEMA, indirect taxes. It could also have implications with regards to corruption, TMLA, now Benami Transaction Act. These are all economic offenses, and the new statutes that have come out, the new statute books that have come out, are being increasingly aggressive in making sure that economic offenses do not go unpunished. The next interesting topic that we are going to deal with today is abetment. I apologize to all the viewers. It seems that our topics are getting more and more morose, but abetment would be of a special interest to all the professionals out here, because most of the offences that are contemplated under the Income Tax Act directly would refer to assessees. But abetment is something that would affect the professionals also. Let's go into the definition of abetment. Abetment is defined by section 107 of the Indian Penal Code. A person abets the doing of a thing who A. instigates any person to do that thing, B. engages with one or more person or persons in any conspiracy for doing the thing if an act or illegal omission takes place in pursuance of that conspiracy and in order to do things or that thing, or C. intentionally aids by any act or illegal omission the doing of that thing. Explanation: a person who by willful misrepresentation or willful concealment of a material fact which he is bound to disclose voluntarily causes or procures or attempts to cause or procure a thing to be done is said to instigate the doing of that thing. There are three situations that can be said to be of paramount when one can be said to have abetted an offense. A, by instigating a person to commit an offense, B, by engaging in a conspiracy to commit an offense, or B, 3, by intentionally aiding a person to commit it. This is by, I believe, the High Court of Jharkhand. As per the wordings of the statute, the offence of abetment largely goes hand in hand with section 276C1, section 277 or section 271A of the Income Tax Act, though abetment of other offences under various under various offences as enumerated by the Income Tax Act is also possible. What Kerala High Court saw in the case of abetment is that the allegations in a complaint would go to show that the partners had full knowledge of all the acts and manipulations. Regarding the employees of the firm, also there are sufficient allegations in the complaint and prima facie evidence to suggest their complicity in offences alleged against them. The request for discharge of the accused was rightly declined by the magistrate. Hence, the Kerala High Court in this case upheld the request of upheld the order of the Honorable Magistrate that refused discharge for partners of a firm and employees of the firm when there are sufficient allegations in the complaint and prima facie evidence to suggest that they were complicit in the offences that have been alleged. The complaint under section 276, 277, 278 and 278B cannot be quashed merely because the accused is a nominee director and not expected to participate in day-to-day conduct of business, as the difference between a nominee director and any other director would be a matter of evidence. This is laid down in 196 ITR 335 Madras. They say that a firm or company being an artificial juristic person was not liable to be prosecuted for offences under section 277, 278. Powers were used for quashing in the case of Kerala High Court and Allahabad High Court. However, it is as far as offences is concerned, section 278B provides for offences by companies, and section 278B provides for offences by companies and artificial juristic entities. Hence, we cannot say that there would be no repercussions under these sections just because they are artificial juristic persons. It just means that the company itself would not be prosecuted, but the people in charge would definitely be prosecuted, the partners in case of a firm, or the directors who are in charge of the running of the firm, as brought out by section 278B in the case of which provides for offences by companies. The question again is Kerala High Court also suggested in the Kerala High Court also laid down in 1982, as back in 1982, that whether a company can have mens rea and whether no individual acts against other accused have been indicated or not, and whether or not they are roped in by virtue of group liability is a matter of evidence. Hence, even when it was earlier seen that there are different views on whether these are all old case laws in the 1980s, but even then the debate was well and alive, saying that if a company or a firm has committed or is accused of committing any offense, whether it can be prosecuted against. There are certain high courts that say no, they cannot be prosecuted against, proceeded against, while Kerala High Court has said that even the issue of a company having mens rea or whether or not the other accused are roped in together by virtue of group liability is a matter of evidence. Hence, quashing will be disallowed. What happens usually in case of charges of abetment can continue even when charges for evasion or making false statement may be shown to be wrong. So if the charges of abetment though go hand in hand with other offences, they are also independent. A person may always show that he did not have the necessary mens rea for evading tax or making a false statement. However, it is up to the abettor, the person who has been accused of abetting, to show that even he lacked the necessary ingredients of the crime, that even he did not have mens rea. This is laid down in 1992 by Madras High Court. This is the interesting part. We refer to abetment by professionals. I have tried as possible to put ITR citations so that it would be easy for people to look it up. There are a couple of other judgments also which I have not been able to put in, but they will be put in. unless there was evidence to indicate that the additional material which had been unearthed during the seizure had also been placed before the auditor, and despite the same, the latter prepared false returns, made the first accused sign the same, and delivered it to the department, the auditor will not become liable under any one of the provisions of the law. This is laid down by Madras High Court in 1987. This has been relied very heavily in the subsequent Madras High Court decision. In this case, there was a search and seizure proceedings, and it was found out that there were some contradictions that were there, and the Madras High Court said that the additional material which had been unearthed during the seizure, unless it is shown that they have been placed before, they were placed by the auditor, and despite the same, the latter prepared false returns and made the first accused sign the name and delivered it to the department, the auditor will not become liable under any one of the above provisions of law. Needless to say, this judgment does leave a lot of tribal issues, so might not necessarily help a lot for quashing, but yes, it could bring out a prima facie case. The subsequent judgments usually refer to this judgment. They say that the averments made, Madras High Court later in 1996 has held that averments made are a matter of evidence. Whether there was inducement, if so, what was the part played, are all matters of fact to be decided in trial. Mere giving of an aid will not make an act of abetment an offence if the person who gave the aid did not know that an offence was being committed or contemplated, but where, according to the case, forged documents were being procured by the accused and were annexed in the return to claim refund, the said prosecution cannot be quashed. To the High Court of Jharkhand. When any assessee wrongly claimed deduction under section 80DDB based on a certificate issued by doctor, and where there were specific allegations against the doctor, the complaint against the doctor would also be maintainable. Hence, we can see that none of the professionals are spared. You can always be accused of abetment. We will also go into this aspect of abetment that more often than not, courts are not very happy or not very willing to quash proceedings, especially in cases of economic offences. The problem is that most of the issues that are relevant, the relevant issues in prosecutions, are all subject of giving evidence. Even showing that there is no mens rea is a matter of evidence. The fact that you have given only have only provided aid, and whether you have given forged documents or not, whether the certificate that has been given by a professional to the accused is true or not, or whether there are additional materials that were before a professional while he was giving his professional opinion was actually there or not, are all matters of evidences. It is also paramount to see that the trend that we can see from all the judgments that have recently been quoted is the High Courts and the Supreme Courts are not that they're not that happy, they're not that proactive in quashing complaints. This is because, again, quashing would mean that that person gets acquitted of that the proceedings cease to exist. When proceedings cease to exist without leading of evidence, usually there is certain amount of mismatch. Hence, whenever there are triable issues, whenever there is prima facie evidence against the accused, whenever the questions that have been brought out in the application for quashing, which show that their evidence needs to be led on such matters, the High Court or the Supreme Court usually refuse to quash such matters. The same issues would be there in discharge, because quashing and discharge are highly subjective. They depend upon the court, they depend upon the jurisdiction of the court to just look at prima facie material without going in depth into the evidence. The courts are usually reluctant to quash or discharge accused without there being a very strong prima facie case that either proceeding against the accused would be abuse of process of law, or whether there are no averments made in the complaint itself against the person. Section 277, false statement in verification, is extremely important because it says that if a person makes a statement in any verification under this act or under any rule made thereunder, or delivers an account of statement which is false and which he knows or either knows or believes to be false or does not believe to be true, most of us professionals, if we do get prosecuted against, or not per se prosecuted, but if even abatement charges are put in, section 277 would be the section that would be the most applicable. There is a case law on this. Unfortunately, I had the wrong citation, but when this presentation is put up on the website, the final citation will be there. It referred to an income tax practitioner who was accused of, directly accused of under section 277, and the complaint against him was not quashed. The other hot topic that I've been asked to cover today is compounding of offenses. Now, compounding of offenses is not really just an income tax thing. It is, of course, provided by I believe CRPC. I think there's a mistake out here. Compounding of offense under section 328 of CRPC have the effect of acquittal of an accused upon which the offense has been compounded. If so, the basic idea is that if compounding is done, then the person who against whom compounding who has removed the whose offense has been compounded will be assumed to be acquitted of the charge. Hence, he cannot be proceeded against on the same issue because double jeopardy will apply. Income Tax Act section 279(2) provides for any offense under chapter 12 to be compounded by the appropriate authority. Compounding can be done before or after institution of the processes for any offense under chapter 12 of the Income Tax Act. It gets even better. A case can be compounded at any time before the sentence is pronounced, even when the magistrate is writing the judgment. This is held by Karnataka High Court. The power to compound can be exercised at the trial stage or even at the appellate stage, subject to satisfaction of conditions that are postulated by the legislature. This is a Bombay full bench judgment, a Madras High Court judgment, and 2 Madras High Court judgments on the same. Technical offences under the Income Tax Act cannot be compounded after filing of complaint. This is Delhi High Court in 337 ITR 251. It is also brought out that even though after conviction power can be exercised to compound an offence, but this by itself cannot be a ground for issue of mandamus sought in the petition. A power of compounding is discretionary. This is Punjab and Haryana High Court. This basically says that there is no bar even after conviction of an accused to get the offence compounded, but that does not mean that compounding can be forced. Mandamus as a writ petition, you cannot qua a mandamus writ petition seek to enforce compounding. Power of compounding is discretionary with the relevant authorities. The Punjab and Haryana High Court has also brought out another interesting ratio that where offer to compound was made by the department but refused. There was no defect in the department refusing compounding after conviction. Hence, though there is no real bar on compounding, even after a lot of issues come up before compounding. Usually, compounding is done before institution of the trial itself, simply because no one wants to undergo trial, no one wants to go to the entire process of going through criminal proceedings. But it is interesting to know that even after conviction, there is a chance that you can compound the offence and be acquitted of it. Also, it is extremely interesting to see that compounding basically means you are at the mercy of the department, because even in case of a regular offense, compounding can only be done by the person who's affected and by the accused himself, both coming together, agreeing to certain and agreeing to compound the terms. It has to be mutual. It cannot be forced. In the same way, you cannot force the department to compound the offense. As we just saw in the case of Punjab and Haryana High Court, power of compounding is discretionary. So the power, the authority that wields that power cannot be forced to compound the same. And this can be the final case law that we saw as far as 334 ITR 265 Punjab and Haryana was concerned. It was very clear that if compounding would have been accepted by the department, it would tantamount to abuse of process, because the offer to compound was already made and refused. And then again, and after conviction, the accused decided that he wanted to go in for compounding, and the department turned him down. Compounding under 279 on Income Tax Act, we can go ahead. There is a recent judgment by Delhi High Court saying CBDT cannot insist on predetermining of compounding fee without considering application of compounding. So they cannot say that you deposit the compounding fee and then we will decide your application of compounding. The application of compounding needs to be considered first. Various board circulars have been issued by CBDT. We shall go into one of them soon enough. Guidelines issued by the CBDT do not constitute a bar for consideration of application seeking compounding of an offence without having regards to the fact of the case. Hence, the guidelines issued by CBDT cannot be blindly followed. The facts of the case need to be appreciated by the compounding authority. This is a 2017 Delhi High Court judgment. Madras High Court and Delhi High Court have also reiterated what the Punjab Haryana High Court said, that the power to compound an offence is discretionary. And the Supreme Court says that 279(2) cannot give any party to insist that an offer of compounding must be made before prosecution is launched. We shall also go into general principles regarding prosecution, but let us before that just go briefly through the circular that is for compounding that has been brought up by F number 285/35/2013. This was guidelines for compounding offences under direct tax laws. It basically says the same thing. Compounding is not a matter of right. Applicability of these prosecution under Indian Penal Code cannot be compounded as per guidelines. However, section 321 of Criminal Procedure Code 1973 provides for withdrawal of such prosecutions. They have broadly classified offences under category A and B. But the takeaway from this is that usually what will be seen, the eligibility conditions is that you have to make an application to the authority having jurisdiction over the case for compounding the offence in the prescribed format. You have to have paid the outstanding tax, interest, penalty, and any other sum due relating to the offence for which compounding has been sought. The person has to undertake to pay the compounding charges, including compounding fee, the prosecution establishment expenses, and the litigation expenses, including counsel fee, if any, determined and communicated by the CCIT, DGIT concerned. This would really be relevant if compounding is not sought right at the outset, but into the trial. The person can also undertake to withdraw the appeal filed by him in the case the same as bearing on the offence sought to be compounded. In case such appeal has mixed grounds, some of which may not be related to the offence under consideration, the undertaking may be taken for appropriate modification of such ground of appeal. Category A offences as brought out by the same circular, usually they suggest that the compounding should not be allowed if in the case the compounding was allowed in the past, an offence under the same section for which the present compounding has been requested on 3 occasions or more. But category B are placed on a different pedestal. The most important offences like 276C, 276C1, 276C2, 276CC are covered under category B. It means usually the first offence you can get it compounded, subsequent offences, well, best of luck. There is a procedure also laid down, but this is pretty much as per the circular. There are various provisions and circulars are brought out from time to time as far as compounding are concerned. Again, we have to figure this has to be read in light of the Delhi High Court judgment that say that guidelines issued by CBDT do not constitute a bar for consideration of application seeking compounding of offence without having regards to the fact of the case. A compounding authority has to go through the facts of the case and then pass the reason orders, either accepting or refusing compounding. But doesn't change the fact that, of course, compounding is completely a discretionary matter. We'll go into general principles regarding prosecution. Before the grant of sanction by Commissioner for Prosecution, there is no opportunity of being heard that is required to be afforded to the assessor. It is important. In 2003, I believe 263 ITR 550 is the Supreme Court judgment, unless I'm mistaken. Unfortunately, I'm not put it in. mere expectation of success in some proceedings under the Income Tax Act cannot come in the way of institution of criminal proceedings. Under section 276C, 277, they held by the Supreme Court in 194 ITR 696. Finding of fact of the tribunal in favor of the appellant is relevant in the prosecution proceedings, where penalty order was set aside, holding that there was no case for concealment made out, pending prosecution under 276C, 277 were liable to be quashed. Where a public prosecutor that is appointed by the central government made an application for seeking consent to withdraw the prosecution, there was no question of the public prosecutor obtaining permission from the central government to get the same thing. Madras High Court. The question of whether the complaints had been lodged at the instance of the commissioner or at the instance of the deputy commissioner with sanction of the commissioner was a question of fact to be considered by the trial magistrate, and the writ court could not go into that question at this stage, especially when there was nothing to show that there was a patent error leading to manifest injustice. To recapitulate, let us just get into the basic ideas. First off is that, of course, prosecution would go hand in hand if there is a finding of fact in the tribunal in your favor, in favor of the appellant. It is also relevant in prosecution proceedings. Just because you expect a success in some proceeding under the Income Tax Act, you cannot say that criminal proceedings cannot be instituted against you. Of course, no opportunity of being heard is required to be afforded to the assessee before grant of sanction by commissioner speaks for itself. Also, where penalty order was set aside, holding that there was no case of concealment made out, the pending prosecution under 276C and 277 were liable to be reversed. This is a landmark Supreme Court judgment simply because this would say that 276C, which is one of the more serious offenses, 276 and 276C and 277. This means that in case there's a penalty order in your favor, then the prosecution could also be caused. I believe the penalty order that was set aside in this case was not by the tribunal but by the Commissioner of Income Tax that needs to be gone into. Of course, a public prosecutor being an authorized representative in the trial court can of course make an application for seeking consent to withdraw prosecution, and there is no question of him obtaining special permission to get the same thing. The last one is relevant only for one simple fact. We've been stressing again and again that the courts are not willing to quash prosecutions at an earlier stage unless you show that there is abuse of process of court or of some court, or there is a patent error leading to some manifest injustice under the writ petition, under the writ jurisdiction. If you cannot satisfy the court that there is something really wrong or some real injustice is being done to you, usually all the issues that are gone into can be considered as matter of evidence, and evidence will have to be led. If evidence has to be led, then it goes without saying that the accused will have to undergo the rigors of the trial court. Most of the judgments that have been brought out, most of the case laws and authorities that have been relied upon us in this presentation are specifically with respect to quashing, simply because it is in our accused's best interest that he not go to jail or the prosecution proceedings do not proceed in front of him. That would not automatically mean, because there are so many judgments on either side that state that every case has to be looked at on case-to-case basis. All these judgments are rendered with specific, are rendered to specific averments in the certain to specific averments in the complaints or with specific facts of the case. It is possibly impossible to be completely covered in the same issue. But of course, the fact that when a penalty order is set aside holding that there is no concealment, the prosecution can be quashed is possibly a very strong judgment in the hands of an assessee whose penalty has been set aside to avoid prosecution. Well, before we get into reasonable cause, it is very important to know that, well, we are all aware that the burden of proof in a criminal prosecution is more often than not beyond reasonable doubt. It means the prosecution has to prove that the person who committed the offense is guilty beyond reasonable doubt. However, Section 278 of the Income Tax Act says that no person shall be punishable for any failure referred to in the said provision if he proves that there was a reasonable cause for such failure. Reasonable cause as per Section 278 AA can be decided based on the evidence adduced by the parties before the competent court. That's what the Supreme Court says. So again, reasonable cause, invoking reasonable cause at the preliminary stage, at the stage of quashing, would again be extremely difficult, because the reasonable cause would need to be proved by leading evidence to the same. Calcutta High Court says that the provisions of Section 278 AA will no doubt be available to the appellant to its benefit if it is able to prove that it has sufficient and good reasons for committing the default. Quashing was denied, and it was held that it was a matter of evidence. Patna High Court says that when the penalty is dropped, the Patna bench says that when the penalty is dropped, the criminal court cannot, in spite of a finding by a statutory authority under the Act that the assessee furnished good and sufficient cause for not deducting and paying the tax within time, take a different view and hold the failure on part of the assessee was without a reasonable cause or excuse. This is extremely relevant because just in the earlier slide, which we shall go back to, we have said that the finding of the fact of the tribunal in favor of the appellant is relevant in the prosecution proceeding. This is a direct extension of that. So what the High Court said, that when penalty was dropped, saying that the assessee has furnished good and sufficient reasons for not deducting and paying the tax within time, the court, the trial court, the criminal court cannot say that, cannot go against it, simply because the authority that is saying that the assessee has furnished good and sufficient reasons for not deducting and paying the tax without time is one constituted specifically in that field and has passed the and is technically sound in that field, and hence the criminal court cannot go against it. Now we get to mens rea, which is possibly the biggest thorn in the side of income tax prosecutions. This would possibly be the most important part of your criminal prosecution if you actually get prosecuted, if charges are framed, if evidence is led. What is always to be held, to be kept in mind is a lot of the offences under the Income Tax Act happen either because of commission or omission. Of course, all offences happen because of commission or omission. But mens rea always has a certain state in criminal jurisprudence. Everyone, of course, knows the famous Dharmendra Textiles judgment, where it was held that penalty proceeding mens rea is not relevant. And hence, the Honorable Supreme Court said then penalty, it does not, the penalty proceedings would not depend upon the mental status of the person, whether the intention was there or not. However, just to make sure that the accused do not get away from prosecution under Income Tax Act, the presumption has been inserted by Section 278E of the Income Tax Act. Usually, of course, we've already touched this. The basic rule of criminal jurisprudence says innocent until proven guilty. However, Section 270E of the Income Tax Act presumes the existence of a guilty mental state of mind. The court has to presume the existence of a culpable mental state, and the absence of such mental state can be pleaded by an accused as a defense in respect to the act charged as an offense in the prosecution. Supreme Court. Court in prosecution of an offense like Section 276CC has to presume the existence of mens rea, and it is for the accused to prove the contrary, and that too beyond reasonable doubt. This is 2014 Supreme Court judgment. This pretty much solidifies the fact that the accused has to prove that he had mens rea, and he not only has to prove mens rea, prove the absence of mens rea, but he has to prove that beyond reasonable doubt. Madras High Court went a bit into the reason behind Section 278E. It says that the impugned provision has been introduced to remove the weakness in the provisions in the direct tax laws in respect of penalties and prosecution, so as to shift the burden of proof on the assessee and to provide that once evasion of tax is proved, the intention to evade need not be proved. It is to be considered also that in 2015, the Supreme Court in the case of Nilofer Karimboy has granted leave along with continuation of stay against the order of Delhi High Court in judgment of the same name in 219 Taxation 102, which held that the lower courts were wrong in granting discharge to the accused based on whether the explanation given by the assessee in the reply to show cause was rightly rejected or not, because it held that presumption under 278E would operate against the accused. Hence, the lower court was wrong in granting discharge. The Supreme Court for now has granted leave and has continued the stay against the order of the Delhi High Court. Further news is yet to come in. What is important is Section 278E. The presumption which is raised is not absolute but a rebuttable presumption. It is quite similar to the Negotiable Instrument Act that has a similar presumption, but I believe that the presumption there has to be proved to the preponderance of probability and not beyond reasonable doubt. But that is again a subject for a lot of case law. The burden of proof may be shifted by presumptions of law or fact, and presumptions of law or presumptions of fact may be rebutted not only by direct or circumstantial evidence, but also by presumptions of law and fact. With respect to the Negotiable Instruments Act as laid down by the Supreme Court, which basically refers to the shifting of burden of proof by adducing evidence with respect to the presumptions of law and fact. The presumption in this case is only of mens rea. The presumption is only about the guilty mind, not about the other ingredients. The entire concept behind this, as shown in the earlier slide by the Madras High Court, would go to show that once the evasion of tax is proved, the intention to evade need not be proved. In a similar way, it has to be proved that the offence is committed first, and only then, if the offence is committed, then and only then do we need to go into the question of mens rea, and then the presumption would step in. What is important is that the Supreme Court has written that has held that beyond all reasonable doubt does not translate to beyond all doubt. That is about the burden of proof. Supreme Court also says in 1988 that a reasonable doubt is not an imaginary, trivial or merely possible doubt, but a fair doubt based on reason and common sense. It must grow out of the evidence in this case. So to pretty much sum up beyond reasonable doubt, we have to look at the basic. The Supreme Court has laid down substantial case law. First of all, it has held the fact that you need to prove beyond reasonable doubt the absence of mens rea. In normal criminal proceedings, it's the other way around. The state has to prove that there is existence of mens rea. In the case of income tax prosecution under Section 278E, you have to show the absence of mens rea. The presumption is only with respect to mens rea, not with the occurrence of the crime itself. The presumption would not extend to the actual occurrence of the crime, that you have actually done the crime. But if it is actually proved that the crime was committed by you, you cannot, without leading evidence, without rebutting the presumption that you have, without rebutting the presumption of possessing mens rea, you cannot get acquitted. What is important is beyond all reasonable doubt does not translate to beyond all doubt. A big debate about this was also done in the landmark case of Nanavati, which was there in the Bombay High Court, and the trial system was abolished by it. The reasonability of a normal man going and shooting someone was considered. There are a lot of judgments with respect to beyond reasonable doubt, and what would constitute beyond reasonable doubt, what would be beyond all doubt. It basically boils down to this: you would have to prove that basically you will have to prove that your defense, the absence of mens rea is not imaginary, trivial, or merely possible, but it is a fair doubt based upon reason and common sense. It must appeal to a reasonable person. A reasonable person must believe, based on your evidence, that you did not possess mens rea. That, of course, has to be adduced by evidence and by your conduct. Just turning back to what is chapter 12 itself, we have pretty much covered the procedural part about it. That would not be apparent only from the Income Tax Act itself. It can obviously be seen that abetment of false return, punishment for second announcing, most of the offences that are contemplated under the Act speak for themselves. There are certain offences that are to be non-cognizable, proof of entries in records and documents. There have been efforts to specify whether certain offences are compoundable or not, but it is quite clear that the section regarding compounding speaks for itself. Now, the general rule of thumb that can be applied is that in case of those, this would not be all pervasive, of course, but in those cases where the sentence that has been prescribed is rigorous imprisonment of not less than 3 months, but which may extend to 7 years, etc., which is sentence in quite a few cases, would be a non-cognizable case, which would be non-bailable in nature. However, on the same footing, if the punishment is small, rigorous imprisonment up to 2 years, then it would possibly be bailable. Again, that would depend upon whether it's a summons case or warrant case as per CRPC. All the cases are to be tried by special court or the magistrate of the first class. That is the section 280A provides for special courts to be set up, and the offences will be tried by special court, and 280C provides for trial of offences as a summons case. We've already touched on 280D. It is the reason why we've had this entire presentation, because CRPC applies to proceedings under the Income Tax Act. We as tax professionals, direct tax professionals, are far too complicit in saying the Income Tax Act is a code by itself. The rules of evidence do not apply. CRPC, CPC will not apply. But apparently section 280D begs to differ when it comes to offences and when it comes to prosecution. So I hope this session was informative.
A lot of questions.
No, we'll take up questions. What has to be considered is that criminal law per se is a very deep subject. We have touched not even the tip of the iceberg. These are certain judgments that are reported that can be brought out. There could be contrary judgments on the same court taken subsequently. There are new judgments coming up every day, because CRPC itself is so dynamic, because it is evolving by the day, because of the number of criminal appeals that are coming in. There is no standard rule of thumb. We are hoping that this is proving out to be helpful, at least as far as procedures to be concerned. When I was approached to take this presentation, as far as possible, I thought, let us try to make sure that this seminar or this webinar gives food for thought to those tax professionals who wonder how to get my client out of jail. That could be the summation of all of it, about how to get your client out of trouble. Because if we delve deeply into every offense, a lot of things would come out, and that possibly would be a topic for some other day. Thank you. We'll take questions now.
Yeah.
Can I see?
Huh? It's there on the screen.
Oh, wait. It's in chat?
It's in questions. There
Okay.
is a separate section.
Yeah.
This first question is that prosecution notice is issued to more than one director. And will the compounding fee be payable only once, or will it be payable 4 times?
See, the thing is, for that you will have to refer to, again, how many directors are made co-accused. Now, what happens is one person cannot compound for everyone. If you are an accuser, if you need to compound the offense, of course, as we've already gone into compounding, the entire it is between the accused and between the department. But of course, it would you would have to look up CBD circulars that are coming again and again. But in my opinion, compounding for one person would just release him, would not release the others.
You have to pay for that.
Or alternatively, you can apply for discharge, saying that only one director was actually in charge of everything.
Whether the revised guidelines being applicable from 7th February 2000 can the compounding fee be calculated from offences on or after 7th February or before that?
They don't seem to have retrospective application as far as
only from 7th February.
In my considered opinion, please, most of the questions that I answer out here are based on my research. So please do not construe them as legal advice. You will have to possibly get more in-depth research into the said thing. But these fees would not, according to me, be retrospective. However, if I get the question wrong, it would mean to offences before or offences after?
Offences before.
Okay, then I stand corrected. The compounding itself might not be retrospective, but what happens is it depends upon when you compound it. Your issue would not rise upon when the offense is committed. The offense could be committed 3 years back. But the question is, if I am trying to compound it today, what would be the conditions on which compounding would be granted to me today? For that, it would be based on what the current rules are, or what the current circular is.
Just a second. Question answer. Can you please explain and elaborate the real life process after completion of hearing of show cause notice?
Well, the entire CRPC by itself, the code, gives you an exhaustive list of what happens after the notice is issued. If prosecution is preferred, then of course, in case of a bailable offense, you're arrested and let out on bail. In case of a non-bailable offense, of course, you are arrested and then you have to apply for bail. If you have anticipatory bail and you're arrested, then obviously you will have to convert that into regular bail and stay out of jail on that. Charges are framed, evidence is adduced, as far as documents are concerned, as far as people are concerned, you have to rebut the presumption. Basically, once show cause, the show cause by itself does not give rise to any cause of action. The show cause is just asking you for justification why you believe that prosecution should not be launched against you. If once you reply to the show cause, they will have to proceed on the footing that if they wish to go ahead, then they will launch prosecution and the procedure as per CRPC will apply, which is quite exhaustive.
Whether CIT has power to drop prosecution proceedings after hearing reply to show cause notice for offences under 276C1 and 276C2. CIT has the power to drop prosecution proceedings after hearing reply to show cause notice for offence under section 276C1 and subclause C2.
On the first instance, I will say issuance of a show cause by itself does not mean that the CIT has started prosecution proceedings. Show cause per se means that the CIT or whatever the concerned authority that is issuing the notice is asking you to give a cause why prosecution should not be launched against you. Subsequent to that, once prosecution lodged, you obviously have the choice of going in for compounding or for the various authorities are there. But the CIT or the authority that is issuing the show cause to you cannot drop the prosecution proceedings, because at the stage of issue of show cause, there is no active prosecution against you. You are not being prosecuted. Yes, if there are any questions, of course, we'll be glad to entertain them. We are putting up these journals online. It'll also be my endeavor to possibly answer a few more questions based on the queries raised by y'all as far as compounding is concerned, after doing a bit more specific research myself based on the queries raised by y'all. I hope this session was informative. Thank you. Yeah, and please remember that these are my own personal views. This is not to be construed as legal advice. Case law differs, people's opinion differs. Please go to your own advocate or go to your own tax professional and get an opinion from him, because he will possibly argue out your case. Thank you.
Friends, we'll all agree that Aditya has taken us through the prosecution proceedings in the most lucid manner. He's brought to our notice the entire set of case laws which are covering the entire process. He's also been kind enough to agree to answer the questions on them in a detailed manner, and we'll put it up on the website. So I request you to, and I, on behalf of Chamber, thank him for the effort and time taken out to give this lecture. Thank you. Good. Excellent. Yeah.